Good morning, YouTube. How y'all doing? Um, First day of Young Dolph trial. Well, yesterday was the first day of Young Dolph trial. So we're gonna watch this. We can't see the faces or nothing, but we're gonna watch. We're gonna listen to it together. So I'm Melanated Queen, Bella DeSandra. So here we are, Lord. I come to your throne. Thank you for waking me up this morning, Lord Jesus. Lord Jesus, as we watch this trial, Lord Jesus, let's be understanding and let's understand what's really going on, Lord Jesus, and we could talk about it. In your mighty name, Jesus, I pray, amen.
Are yours, don't you? Yes, sir. I want to skip forward. Okay, we're gonna go back to. All right, what's up with it, y'all? So look, man, I'm back again with another video, right? And this is another update on this Young Dolph trial. Judge, good morning. I'm just checking in for New Market Council. My understanding that which is count one of this indictment, murder in the first degree, which is count two of the indictment, and conviction
Yes, the young man.
count three of the indictment. Counts one and two have not been altered, but count three, the state and the defense have met, and we will have a stipulation during the trial. Mr. Johnson is a convicted felon. We're going to withhold from the jury.
It's the young man right there.
He is convicted. So instead, count three.
One of them anyway.
Been convicted of a felony offense that qualifies under TCA 3917, 1307B, 1A. It does not say the title of the offense, which is aggravated assault. This stipulation is consistent with case law. Mr. Johnson's going to, Mr. Evans, Mr. Johnson are going to sign that during the trial. So
you go here.
I guess is the proper terms for that. And I think the court has a copy.
You go here. His partner that helped unalive young Dolph, he testifying against him.
Of the sanitized indictment.
Yes.
Very good.
You have the stipulation already typed.
We do. We have the sites, and Mr. Evans has reviewed it. I think he just needs to get his client to review it with him.
That's correct. And at some point, we'll make that an exhibit.
The second thing, obviously, there's cameras and media in the courtroom. There are also incredibly heightened security risk, security concerns during this trial inside this courtroom and outside this courtroom. This is one violent act and serious violent acts that have occurred in this case or around this case. There's witnesses that have true security concerns now and going forward after this trial. And there's also family members who have certain privacy rights and security concerns as well. I've been asked by several of the witnesses and by several of the family members, or maybe all of the family members, that I request from the court that the media not be allowed to film their faces during this trial or on their way in and out of the courtroom. This is a request that other judges in this building have granted numerous times when there's security implications like this, and that's what I would ask for, Your Honor. When they testify, it's customary in those circumstances that basically they film the feet of the witness, but obviously the audio and everything public. But I'd make that request with regard to several of these witnesses and all the family members coming in and out of the courtroom.
So let me make sure I'm clear about your request, that media not be allowed to film family members' faces or witnesses' faces, or both.
Yes, and not be able to film family member faces as they come in and out of this courtroom.
Okay.
But they not be allowed to film the two family members that would be the first two witnesses, their faces.
Okay.
And then going forward, maybe before we call a witness which is a particular security concern, we can address, Your Honor, as to whether or not they're able to film the faces of those particular witnesses.
Mr. Evans, any objection?
I have no objection to that, so long as the defense would be extended the same courtesy if there was a particular witness that we needed to call. So that's
All right.
The final thing we'll put on the record now
Let me address before we go further. You want to step aside for a second? Speak to Dean, my cameraman back there. Dean, so I'm going to grant the state's request that to meet the family members, and whom you're going to know, because they'll probably be brought in very shortly together. Their faces not be filmed as they come in and out of court. Okay, for that their faces not be filmed. I'm going to. This is a security risk. This is a high security issue in trial that we're trying to do this week. So for the safety of the families, I'm going to order that you not film their faces. The first two witnesses the state has informed me will be family members. The court has no problem with filming chest down, feet, but not their faces. Do you understand?
I understand.
Any questions?
Yes.
Yes.
Also, we can do our due diligence. I mean, actually, listen, because I know nothing of this case and I know nothing of anything here. I'm from out of state.
Yes, sir.
So I want to make sure that I do what you tell me. So I have
So
to say.
the public information person, Ms. Whitaker, will let you know.
Okay.
This is gonna be her job for right now.
Okay.
To let you know when family members are coming in, for you not to film those faces. And I'm telling you now, the first two witnesses, you won't be filming their faces. From that point, then the state's going to let you know, or let me know to let you know, who, or the defense about with the faces that don't need to be shown. Okay? She got it down. All right, what's the third one?
Just go ahead and tender to the court so the owner can go ahead and sign it. There's a stipulation with regard to the first witness, the corpus witness,
Yes, sir.
that Mr. Evans and I already signed. To each of you.
So let me make sure I understand this. So the corpus witness will be testifying, but won't be shown.
The corpus will be testifying, but will not show the autopsy photos and corpus witness.
So this is a stipulation of fact. I shall read it into the record right now. You have an objection to that?
No objection.
The parties in this matter, the state of Tennessee, represented by Paul Hagerman and Iris Williams, and the defendant Justin Johnson, represented by Luke Evans, respectfully have agreed to the following. The victim in this case is Adolph Thornton Jr. He was a living person who is now deceased. Adolph Thornton Jr. was, as you will hear in later testimony, the same person that autopsy 2021-2619 was performed upon. These are facts agreed to by the parties and may be accepted as true without the need for a witness or further proof. This is a stipulation made in all homicide cases so that family members of the victim do not have to be autopsy pictures of the victim. It's so stipulated and approved by the court.
I'll grab that from the clerk. And then the final thing, yes, ma'am, we'll do it with the corpus witness. We'll do our first witness.
Okay.
So Ms. Williams can get that from your clerk here in a second. The final thing is Mr. Evans and I have both worked hard and had numerous meetings with each other in an attempt to sort of go ahead and address and sort of pre-trial, many of the pre-trial sort of matters. So let me put one thing on the record to sort of allay any concerns Mr. Evans may have, but also give the court a heads up. And it may be that with a couple of these witnesses, before they actually testify, we may need to have the jury out so your honor can admonish the witnesses with regard to one thing. There are other acts of violence. I think I mentioned other acts of violence that are related to this case. That at least two of the at least two of the prospective witnesses are aware of or present for. And these are acts of violence in which Mr. Johnson also personally engaged. Whether or not those are relevant to this case, it's the state's intention not to put on evidence or elicit testimony with regard to these other acts in this trial. And that's something Mr. Evans and I have talked about sort of at length, and we've come to sort of that understanding with each other. And so before that particular witness testifies, I think it'd be smart to have the jury out and just instruct the witness again that we're not going to talk about those other crimes. Obviously, that's for our case in chief and for direct. Where cross-examination goes or whatever is a different story. But I want to lay any concerns. I won't be talking about other crimes or other acts of violence in my opening or anything like that. Our plan is to proceed on this act.
Anything else to add to that, Mr. President?
So the only thing I would add, Your Honor, is obviously Mr. Johnson in no way concedes that he committed any of the other acts, but other than that, what Mr. Haggerty has said is accurate, and we can have another talk about that.
Thank you. We probably need to make that stipulation in the city.
We
You
can,
want to do that now, or you want to wait?
well, we can do it as soon as I have Josh, Your Honor wants to.
Anything else?
Judge, I just have one issue bring to the court's attention. When we were doing jury selection, I made a motion to allow Mr. Johnson to sit at counsel table based on his right to a fair trial and to assistance of counsel. Your Honor denied that motion initially. I'm renewing that same motion today so that he can be allowed to sit at counsel table and assist us. During the trial, and one case in point is, as Your Honor remembers, one of the jurors that we were hired gave his impressions, and we were hired on it somewhat about getting the sense that somebody wasn't engaged with the lawyers, that would give him a sense that they didn't really care about their case. Although other jurors didn't state that on the record, that is the concern for prejudice, Mr. Johnson, and his right to a fair trial. Also, the ability to converse with us via table, be able to view things without us having to turn around when the trial's going on, is paramount to him being able to fully exercise his right to counsel.
During the jury selection, I specifically remember you asking a particular juror, was her thoughts about the defendant and what he may or may have not done in the past, affected by the fact that he wasn't sitting at counsel table. And she specifically said, that didn't have anything to do with why she felt the way she felt. That juror was you had the ability at that time, as you needed, to ask how people thought about that. So I'm going to continue to deny that request.
Thank you.
And before we get started, juror number 4 was a no-show, so she has been excused.
Granddaughters have worked hard to excel in sports. Sherrod Brown voted to allow transgender
Anything else we need to take up before we bring the jury in?
No,
You want to bring the family in before the jury comes in? You want to bring the family in? You see,
This from the Law and Crime. This from Law and Crime. Young Dolph murder trial. I'm not showing them, but Justin Johnson, he wanted to defend it. I'll move this a little forward. I want to say this. I don't suggest nobody go out there and commit no crime and none of this. But if you're gonna do it by yourself. And only way you're gonna give yourself up is through cameras. So I advise you, just don't do it and obey the law. Because if you got somebody with you doing a crime, you best believe they're gonna get themselves out of it by testifying against you. So don't do it. Because when you come to crimes, you ain't got no friends.
you raise your right hand. When I finish, you can just all say, I will. Do you solemnly swear or affirm to well and truly try the issues that traverse herein, join between the state of Tennessee and the defendant, Justin Johnson, upon a true bill of indictment, charging him with the offenses of conspiracy to commit first-degree murder, murder in the first degree, and convicted felon in possession of a firearm. A true deliverance makes and a true verdict renders, according to the law and evidence, so help you God. Thank you. You may see it. Good morning. Before we begin the trial, I would like to tell you a little bit about what will happen during the course of the proceedings. I want to describe basically how the trial will be conducted and what the attorneys, jurors, and the judge will be doing over the course of the trial. At the end of the trial, I will give you more detailed instructions on how you are to go about reaching your decision. But now I simply want to explain how the trial will proceed. The defendant has been charged by the state of Tennessee with a violation of state law. The document containing the charges is referred to as an indictment. An indictment is the formal accusation charging the defendant with a crime and is not evidence of anything. The defendant has pled not guilty to all the charges. He is presumed innocent.
I want to shout out to Law and Crime.
Unless, after hearing all of the evidence, attorney's arguments, and instructions of law, the 12 jurors seated in this case unanimously find that the state has proven its case beyond a reasonable doubt. The first step in the trial will be the attorney's opening statements. The state will tell you about the evidence it intends to present so that you will have an idea what the state's case is about. This opening statement is not evidence. Its only purpose is to help you understand what the evidence will be and what the state will attempt to prove. After the state's opening statement, the defense may make an opening statement if he so chooses. Again, statements of attorneys are not evidence. Next will be the state's case in chief, in which the state will present its evidence. The evidence in the case will most likely consist of physical exhibits, documents, and the testimony of witnesses. The witnesses will testify by answering questions asked by the attorneys. After the state completes its case in chief, the defense will be given an opportunity to present evidence through witnesses and exhibits. A defendant is not required to put on any evidence or to testify. The burden is always on the state to convince you that the defendant is guilty beyond a reasonable doubt. If the defense does present proof, the state may then put on what is known as rebuttal proof. After the state's rebuttal, the defense may put on further proof. After you have heard all of the evidence, the state and the defense may present final arguments. I previously told you that opening statements by the attorneys are not evidence. Likewise, closing arguments are not evidence. In closing arguments, the parties will attempt to summarize their cases and help you understand the evidence that was presented. The final part of the trial occurs when I instruct you about the rules of law that you are to use in reaching your verdict. After you hear my instructions, I will excuse the alternate jurors, and the final 12 jurors will leave the courtroom together as a group. You will then begin your deliberations to make a decision in the case. Your deliberations will be secret, and you will not be required to explain your verdict to anyone. Now that I have described and outlined for you the trial itself, let me explain the functions that you and I will perform during the trial. I will decide which rules of law apply to the case. My decisions will be reflected in my responses to questions and objections the attorneys raised during the trial.
Come here.
facts are from the evidence. You must then apply the law and my instructions to the facts, and from that application, you will arrive at your verdict. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden remains on the state throughout the entire case. Keep in mind that the defendant is presumed to be innocent of the charges against him. Thus, the defendant is not required to prove his innocence, to have his attorney make any statements or arguments, or to produce any evidence. You as jurors must decide whether the state has proven beyond a reasonable doubt that the defendant has committed the crimes charged in the indictment. You must base that decision only on the evidence in the case and my instructions about the law. An important part of your job will be making judgments about the testimony of the witnesses who testify. You should decide whether you believe what each person says and the importance of his or her testimony. In making that decision, I suggest that you ask yourself a few questions. Did the person impress you as honest? Did he or she have any particular reason not to tell the truth? Did he or she have a personal interest in the outcome of the case? Did the witness seem to have a memory of the event he or she testified about? Did the witness have the opportunity and ability to observe accurately the things he or she testified about? Did he or she appear to understand the questions clearly and answer them directly? Did a witness's testimony differ from the testimony of other witnesses? These are a few of the considerations that will help you determine the accuracy of each witness's testimony. In making up your mind and reaching a verdict, do not base any decision on the fact that there were more witnesses on one side than on the other. Likewise, do not reach a conclusion on a particular point just because more witnesses testified for one side on that point. Your job is to think about the testimony of each witness you heard and decide the facts. Some of you have probably heard the term circumstantial evidence and direct evidence. These are the two basic types of evidence that exist in law. Direct evidence is direct proof of a fact, such as the testimony of an eyewitness. Circumstantial evidence is proof of facts from which you may infer or conclude that other facts exist. I will give you further instructions on these as well as other matters at the end of the case. Keep in mind that you may consider both kinds of evidence, which are considered to be of equal value in the law. The court will not provide you with a transcript of the testimony at the end of the trial. Therefore, you must listen very carefully to the testimony. Each of you will be allowed to take notes during the trial for your own use during your deliberations. You are not required to take notes. Independent memory can be as accurate as written notes. During the course of the trial, you should not talk with any witness, defendant, or an attorney involved in this case. Please do not talk with them about any subject matter whatsoever. You may see them in the hallway, on an elevator, or at some other location. If you do, perhaps the best standing rule is to not say anything. You also should not discuss this case among yourselves until I instruct you on the law and you start deliberating at the end of the case. It is important that you wait until all the evidence is received and you have heard all of my instructions on the rules of law before you deliberate among yourselves. During the course of the trial, you will receive all of the evidence you may properly consider to decide the case. Because of this, you should not attempt to do any research on your own or gather any information on your own that you think might be helpful. I do not know if there will be any media reports in the newspaper, on television, on the radio about this case. You are not permitted to read, watch, or listen to any reports. You as jurors must base your decision solely on the evidence you hear in the courtroom. At times during the trial, an attorney may make an objection to a question that is asked by another attorney or to an answer that a witness may give. This simply means that the attorney is requesting that I make a decision on a particular rule of law. Do not draw any conclusions from the fact that an objection was made or from my rulings on that objection. My rulings only relate to the legal questions that I must determine and should not influence your thinking. If I sustain an objection to a question, the witness will not be permitted to answer the question. Do not attempt to guess what the answer might have been had the witness been permitted to give it. Similarly, if I tell you not to consider a particular response that was made or statement that was made, you should put that statement out of your mind, and you may not refer to that statement in your later deliberations. You may not ask questions. It is your responsibility it is the responsibility of the attorneys to present the evidence. You must decide the case on the evidence presented to you. Finally, during the course of the trial, I may have to interrupt the proceedings to confer with the attorneys about the rules of law that should apply. In some cases, we may have bench conferences in the courtroom outside of your hearing. And in some instances, I may ask you to retire to the jury room while we discuss a matter out of your presence. I will try to avoid as many of these interruptions as possible.
Zero 4769, State of Tennessee versus Justin Johnson. So indictment of 3 counts. Count 1 is conspiracy to commit first-degree murder. Count 2 is murder first degree. And count 3 is convicted felon in possession of a firearm. This is count 1 of the indictment. State of Tennessee Criminal Court in Shelby County, September term of 2022, count 1. The grand jurors of the state of Tennessee duly selected and paneled, sworn and charged to inquire for the body of the county of Shelby, Tennessee. Upon their oath, present that Justin Johnson, also known as Straight Drop, Cornelius Smith, Hernandez Govan, and Jermarcus Johnson, between June the 1st of 2021 and March the 1st of 2022, in Shelby County, Tennessee, and before the finding of this indictment, did unlawfully, intentionally, with premeditation, and with the intent to commit the offense of first-degree murder, as classified in Tennessee Code Annotated 3913-202, against the person of Adolph Thornton Jr., enter into an agreement with each other to commit the said offense. The said Justin Johnson, also known as Straight Drop, Cornelius Smith, Hernandez Govan, and Jermarcus Johnson, acting for the purpose of promoting or facilitating the commission of the said offense, and agreeing that one or more of them would engage in conduct which constitutes the said offense. In furtherance of said conspiracy, one or more of the parties to the conspiracy committed an overt act, to wit, Justin Johnson, also known as Straight Drop, traveled to 2370 Airways Boulevard and killed Adolph Thornton Jr. Cornelius Smith traveled to 2370 Airways Boulevard and killed Adolph Thornton Jr. Hernandez Govan solicited both Justin Johnson, also known as Straight Drop, and Cornelius Smith to kill Adolph Thornton Jr. Jermarcus Johnson aided in Justin Johnson, also known as Straight Drop's, hideout and escape after the killing of Adolph Thornton Jr. Aided communication between Justin Johnson, also known as Straight Drop, and Cornelius Smith after the killing of Adolph Thornton Jr. and facilitated payments to Cornelius Smith for the killing of Adolph Thornton Jr. All of which is in violation of Tennessee Code Annotated 3912-103 against the peace and dignity of the state of Tennessee, signed by the District Attorney General for the Greater Patricia District. Count 2, State of Tennessee, Criminal Court, Shelby County, September term 2022. The grand jurors of the state of Tennessee.
My granddaughters have worked hard to excel in sports. Share. voted to allow transgender biological men to compete in
required for the body of the county of Shelby, Tennessee, upon their oath, present that Justin Johnson, also known as Straight Drop, Cordelia Smith, Hernandez Govan, on November 17, 2021, in Shelby County, Tennessee, and before the finding of this indictment, did unlawfully, intentionally, and with premeditation kill Adolph Bush Jr. in violation of Tennessee Code Annotated 39-13-202 against the peace and dignity of the state of Tennessee, again, signed by the District Attorney General for the 30th Judicial District. Count 3, State of Tennessee, Criminal Court of Shelby County, September term 2022. The grand jurors of the state of Tennessee duly selected and panel sworn and charged to inquire for the body of the county of Shelby, Tennessee, upon their oath, presented Justin Johnson, also known as Straight Drop, on November 17, 2021, in Shelby County, Tennessee, and before the filing of this indictment, did unlawfully and knowingly possess a firearm, having been convicted of a felony offense that qualifies under Tennessee Code Annotated 39-17-1307B1A on May the 2nd, 2017, in the Division 8 of the Criminal Court of Shelby County, Tennessee, under docket number W17-00355, in violation of Tennessee Code Annotated 39-17-1307 against the peace and dignity of the state of Tennessee. Going in reverse order, that third count was convicted felon in possession of a firearm. That second count was murder in the first degree. And that first count, long one, is conspiracy to commit murder in the first degree. It's signed by the foreperson of the grand jury. A true bill having been returned on November the 10th, 2022.
Mr. Justin Johnson has to plead.
Mr. Johnson, please, not guilty.
Thank you. Okay.
And welcome to two things first. I told you last week, there's going to be cameras, there's going to be TV cameras, here clicking, right now. When you stood up to take the oath, you probably heard them clicking too. But like we told you last week, and what the judge has instructed each and every one of them, is they cannot film y'all at all. When those cameras were clicking when you stood up to take the oath, they were taking pictures of your judge. As I'm talking to you now, they're taking pictures of me, but not y'all at all. Not at all. Second thing, like I told you last week, we don't have the big windows looking out into the city. We don't have the fancy wood benches in the back. Our room is a third of the size of what we were in last week. That wood behind it, probably not even wood. We got a lot of carpet. But in Memphis talk, we still call this a courtroom. And in this courtroom, the words we talked about last week, presumption of innocence, elements, cases, charges, criminal responsibility, they're not just words. They're the law, and we take an oath to take them seriously and to follow them. Even without the fancy blue benches, what the big one does. We call this a courtroom. And in here, our job is to apply the law to the facts and to do what's right. Welcome to Memphis. Welcome to Memphis, November the 17th of 2021, in the middle of the afternoon, just after noon, about 12:20, 12:21, 2, 3, 4, in the afternoon. So, you get some there. Can everybody see it? Yes, sir. This is Memphis, Tennessee. This neighborhood is close to the airport. It's called Orange Mound. It is a historic neighborhood in Memphis. One of the first predominantly black neighborhoods that had so much history, so much art and culture and such, significance that it used to be compared to Harlem in New York City. There was a time when it was particularly vibrant, had a theater, arts. It was an important neighborhood in Memphis. It is less than 15 minutes from this building. Like I said, it's by the airport. In the 80s and 90s, it became riddled with crime, with drugs, with poverty, with gangs. It is trying hard nowadays to make a resurgence, to go back to what it was. There are families that have lived there for decades, generations. There are businesses and other things that have been there for decades. What we're looking at here is one of those Memphis businesses, a family business. This is the storefront of Makita's Cookies. This is the front of the store. This is its parking lot in front of it. Makita's Cookies. They sell butter cookies, basically. Some have icing on them. This is simple butter cookie. People say they're real good. In Memphis, they say the fire. So we got a cookie store that sells fire butter cookies in the middle of the day at 12:21 in the afternoon.
Mr. Hager, you're speaking from.
You can stop here. All right. So in 2021, people thought that was like a Lamborghini or something, but they hadn't seen the new Corvettes yet, really. They weren't around. That is, in fact, one of those new Corvettes. It has a special wrap on it, is what they call that. It's not something you can buy from the dealership. You have to get that done yourself. Well, here, that's a special wrap that the Memphis rapper, artist, known Dolph, had on several of his vehicles. There's a couple times in this video we'll just have to wait, but it's a matter of seconds, and it's the last seconds of his life, so we can wait for him. You'll stop there first.
That's Dolph right there. Going into the cookie shop.
This taller man here in the yellow shirt, blue jeans, white shoes. His name is Adolph Thornton Jr. You've heard me read it a couple times now. He grew up in Memphis. neighborhood he grew up in was Castelia, not terribly far from this, also a neighborhood in South Memphis. You'll see a member of his family testify this week. She'll tell you a little bit about his background and his family. I'll tell you a little bit about him right now, though. He is an ambitious young man who was a rapper, Memphis rapper, who rapped about the things that he saw growing up.
They come here illegally, and then Sherrod Brown rolls out the welcome mat. Brown voted to give amnesty to
Some of that is drugs, some of that is violence, some of that is crime, some of that is gangs. Whether or not we agree or disagree as to whether or not that subject matter,
Shout out to Law and Crime.
or not, I can assure you it's real. You're after about stuff that is real. You're after about stuff that is real. And one of the things that meant everything to him in terms of what is real is he wanted to make it for himself. He wanted to make it for himself. He wasn't interested. He wasn't interested in joining others. It was all about making it himself. He felt like when he grew up, he called it his come up. That's what he called it, his come up. That it was rough and hard, that it was important, that he got through it himself and he wanted to make it for himself. And he made it for himself. As a rapper, as an artist, young Dolph became famous, shortened to Dolph, very famous. Wanted to make it by himself, wanted to be self-made, but it wasn't just about him.
Hey, Mr. Mika, how you doing? Happy Tuesday to you. You are watching the Young Dolph trial. It started yesterday.
And so he started not just his own rap career.
I'm blessed. God woke me up this morning, Mr. Mika.
Paper route empire. Paper route. Like a young man or woman would have to make money on the side selling papers, but also play on the word paper. Because in Memphis, slang for money is paper. It's sometimes abbreviated PRE, paper route empire. And that is Dolph and the rappers that he promoted.
It's a shame how people be jealous of the next person because of their come up.
On your own.
It's a crying shame.
In this game,
They can do the same thing. They don't have to hurt nobody or take nobody out because of jealousy.
enemies. PRE, Paper Route Empire, his label. It's not the only label in Memphis. He's not the only famous rapper in Memphis. Another label,
Go ahead.
CMG, Cocaine Music Group.
In the act.
they became him.
Yeah, Mr. McGee, it's a shame because he didn't. Short. Because he didn't want to be under nobody. He wanted to build his own, and they get a right to take him out. It don't make no sense, and that's how everybody, these rappers coming up today, that's how they is. But I'm going to turn this back around.
Myself. And in this game, whether it's smart or not, there are things called, some methods we call them diss tracks, DISS. On rap, where I insult, level whatever sort of insults and everything else I want to in the song itself.
Yes, Mr. Mika.
And Dolph had plenty of those. And he had plenty of those directed at this other label, the Cocaine Music Group, at their artist, and at their number 2 person. His name is Big Joe, the number 2 person of Cocaine Music Group. Through the years, and I'm talking years before what we're going to watch, having nothing to do with Mr. Johnson on trial, there are highly publicized incidents of violence directed by CMG against Dolph. He even wrote songs about it. Bulletproof, 100 rounds. And he also spewed out the disses and the insults. Stop it there. This man here got out of the car with Dolph.
That's his brother.
His name's Marcus Thornton. His brother, his friend. This thing that we're about to watch has had a terrible impact on Marcus. Not just his brother and his friend, but he also works security for him.
I ain't gonna tell too much of that because I don't know how YouTube is, but just let you see a little bit.
Dolph is well aware of the threats and the violence from CMG that were constantly hanging over him and his people.
Yeah, I just want to say to the youth, ain't nothing wrong with doing what you love to do, but don't be under nobody like young Dolph was. He didn't want to be under nobody. He wanted his own label. He wanted to do him and not have to be under somebody. And he worked hard for it. Only God knows if these young men did this or not. But if they did, God help their soul. But it's sad Just like it's sad on Young Thug. It's sad how these young men throwing themselves away. One on Young Dolph, he damn near 40-some years old. He didn't even know Dolph. But that quick money, he wanted that money. So I'm gonna bring the other half of this trial to at the Lord's will tomorrow. And I'm finna go on Young Thug trial. And it's something that I don't like on that trial because of the new judge right now. She leaning on the defense side and not letting the prosecutor do their job. So she is biased, and the defense is eating it up. So look like, I don't know, but got to wait and see on that. But I am probably gonna go live on that one too. I think it started today by 9. Okay, thank you, Miss Tamika, for stopping by. I want to, ones that gonna watch the replay, thank you. I love each and every last one of y'all, and y'all have a blessed rest of your day.
You mad? Because you're jealous. Because you don't have the range. Because you can't do the research. Because you don't know what you're doing. And all you can do is just sit on the sidelines and worry about what I'm doing. Anyway, baby.
Maybe I should go over there and